So hi friends, I'm back with my series on DPDP Act 2023. Please note that this is not a legal advice and should be used only for reference and educational purposes. So the Act now defines what are the grounds for processing of personal data basis which processing can be done. So the Act says a person may process the personal data of a data principal only in accordance with the provisions of this Act and for lawful purpose, for which data principal has given her consent or for certain legitimate uses. Now, I can distinguish these grounds for processing of personal data based on consent given and which is non-consent based, that is for certain legitimate uses. To give you an example, suppose when a user signs up for a social media account, they are asked to provide personal data such as name, email addresses, and date of birth. The platform specifically asks for the user's consent to process this data for creating the account. So once the consent is given, this consent forms the ground for processing of personal data. Then one of the ground for processing of personal data is for certain legitimate uses. Say a bank or a financial institution is conducting anti-fraud checks. Now the bank processes customers' transactions data to detect and prevent fraudulent activities. Even though here, in such a case, consent is not obtained for the processing for each fraud check, this processing is legitimate because it is necessary to protect the interest of the economy, interest of the customer, interest of the bank, and is not expressly forbidden by law. So I repeat that the grounds for processing of personal data can be based on consent or it can be based on certain legitimate uses. Now, the Act says that every request which is made to a data principal for consent shall be accompanied or preceded by a notice given by data fiduciary to the data principal, informing about personal data, about the purpose for which the same is proposed to be processed, the manner in which the data principal may exercise her rights, the manner in which data principal may make a complaint to the board. So I give an example here covering each of this notice particulars. Say there is a health and wellness app called FitTrack. Now the notice says that we will collect your name, email address and date of birth and health data such as steps taken, what is your heart rate, etc. So this constitutes personal data. Then it will give notice about the purpose for which the same is proposed to be processed. So the notice reads as the date that this data will be used to provide personalized fitness recommendations, track your progress and improve our services. Now the notice will also mention about the manner in which the data principal may exercise her rights. So it will mention that you have the right, say, to access your personal data. And how can you exercise this personal data? You can visit the My Profile section in the app to view the personal data we hold about you. And lastly, it will also give notice about the manner in which data principal may make a complaint to the board. So, the notice will read as, if you have any concerns or complaints of your personal data, you can contact the Data Protection Board. To file this complaint with the board, you can either visit their website or the contact information is so and so. So the Act also says that there might be cases where the data principal has given her consent for processing of the personal data before the date of the commencement of the Act. Then, in such a case, data fiduciary, as soon as it is reasonably practicable, give to the data principal notice containing the same items: personal data, purpose for which the same is proposed to be processed, manner in which she may exercise her rights, the manner in which data principal may make complaint to the board. So, in such cases, what will happen is that data fiduciary has to give a notice to the data principal, and it will continue to process the personal data until and unless the data principal withdraws the consent. Now, the Act further says that data fiduciary shall give data principal the option to access the contents of the notice in English or any language which is specified in the 8th schedule to the Constitution. And what is the main purpose? The main purpose is that data principal should fully understand for what purpose their data is being processed. So, according to the law, the data fiduciary has to give the data principal the option to view the notice either in English or in any of the 22 languages which are specified in the 8th schedule of the Indian Constitution. Like my video? Then do like, subscribe and share across my channel. Thank you so much. See you again.